right to protest is integral to democracy. But should the right to protest disturb the civic life? Well, that is another important question. Any right, any exercise of right to protest will invariably have an impact on the public life, will have invariably an impact on the civic life. Suppose if farmers are agitating today, so obviously there will be some adverse impact on the civic life there. If there is a Rasta Roko, there is a Bharat Bandh in later this month, there can be a national strike, there can be a procession, there can be a public meeting which involves mobilization of a large crowd. And obviously, mobilization of a large crowd entails hardships for the citizens. So, should we really allow them? But we are only talking about events in a democratic politics. What about events which are nothing to do with politics? On Sunday, we have huge congregation of people for Ganesh Nimajjan. Well, did it not impact the crowd, impact the civic life? Traffic was diverted to suit the peaceful, smooth transition of the Ganesh processions. Well, should we not allow people's right to have a religious congregation just because it will adversely affect the traffic? Well, it's not just politics, even otherwise also. There will be processions of all kinds of religions. So, in a democratic society, right to protest, exercise of right to protest, will invariably impact civic life to an extent. But how do you minimize that impact? So you have to balance between right to protest of a citizen and the citizen's right to have a smooth transition in life, smooth transition on the road. So the careful balancing act has to be done. You can't say let the citizen protest outside Hyderabad. There was time when KCR government in Telangana said, you can't protest in the heart of the city. Go and protest in Uppal. Go and protest in LB Nagar. Well, that can't be the solution because why will people protest? People protest to create a public opinion. People protest to bring some pressure on the government. Well, if you ask people to protest somewhere outside, where it doesn't really catch the public attention, what is the meaning of that protest? So this was a political and legal tangle for quite some time. Ultimately, it went to High Court, and High Court restored people's right to protest at Indira Park, which is called the Dharna Chowk. Same is the case with the Jantar Mantar. So we have to, in democracy, we have to balance between the demands of various sections. So if there is no right to protest, what will be serious adverse impact on democracy? Well, if somebody is exercising right to protest, there may be a disturbance to public life. As the classic example of protest against the Citizenship Amendment Act and NRC, there was a long protest in Delhi. So therefore, what my opinion is, you have to balance. If you deny the people's right to protest on the ground that it adversely affects the public life, or it may create traffic law jams and create problems. But the cost of denying the right to protest is much more severe. The cost of denying right to protest may even lead to eclipse of democratic rights. So right to protest will act as a pressure group on governments. Right to protest, exercise of right to protest will help to create a public opinion on a particular issue which is so vital for democracy. So Supreme Court has categorically said, unequivocally said, that there is no democracy without dissent. So we'll have to balance between the two. That's the reason the Constitution of India gives the state the power to restrict the right to protest, while giving the citizen a constitutional right to protest. It's a very interesting balancing act the Constitution does. On one side, it gives every citizen right to protest. On the other side, it gives the power to the government, power to the state to restrict this right to protest. Then what should be the interrelationship between citizens' right to protest, state's power to restrict it? Well, this is what the Supreme Court should have to explain. Constitution, everything will not be written in the Constitution. Dr. B.R. Ambedkar, while dedicating the Constitution of India to the nation, said, the text of the Constitution may be well superb, but ultimately its effect, its impact is determined by the people, the men and women who implement it. If the men and women who implement the Constitution are those with great ideals and values, if the political culture is truly democratic, the Constitution will be very effective. Otherwise, the same Constitution becomes irrelevant, becomes redundant. We have seen the experience of internal emergency in India during 1975-77, when fundamental rights were even abridged, were taken away. So therefore, how would you implement the Constitution of India? And Supreme Court and High Court, the independent judiciary, interprets the Constitution to make it a living document. Constitution is not a static document. Constitution is not a liar's document alone. It's not a liar's document. It is the spirit of the age. Ambedkar said, Constitution is the spirit of the age. So it has to be interpreted. It has to be understood, analyzed, keeping in view the spirit of the age. So privacy was adjudged as a fundamental right very recently. There was no issue of privacy 50 years ago, 40 years ago. People did not take privacy so seriously 40 years ago. So ultimately, it is the spirit of the age that determines the true essence of the Constitution of India. So Supreme Court, in several judgments, explained the relationship between citizens' right to protest and power of the state to restrict this right. And it said, as I told you in many a time, every fundamental rights in India are not absolute. Fundamental rights are subject to reasonable restrictions in India, whether it is freedom of press, it's a freedom of expression, freedom of religion. Every fundamental right in India is subject to reasonable restrictions. So therefore, right to protest, right to assemble, right to form a union are also fundamental rights, but they are subject to reasonable restrictions, like public order, like morality, like health, etc., etc., national security. If any protest impinges upon the national security, when that can be restricted. So if it seriously disturbs the public order, what is public order? Supreme Court defined in many judgments. Normal disturbance to law and order should not be considered, should not be construed as threat to public order. Public order is a grave danger to the law and order. It's a very serious threat to the law and order is considered as a public order. So unfortunately, quite often governments, police deny permissions for right to protest on the ground that it disturbs the law and order because they don't read the Constitution of India. Even if they read, they don't respect the Constitution of India. The problem with the implementation of the Constitution is the policeman sitting in the police station somewhere may or may not have proper understanding of the Constitution of India. One. Two, even if he or she has read Constitution, he or she may not be aware of the judgments of the Supreme Court and High Court that interpret the Constitution for us. I'll give you an example. Section 66A of the Information Technology Act, which allows the police to file cases for somebody posting something on the social media. Supreme Court in a landmark judgment struck it down. It said 66A is anti-constitutional. But still, several cases are filed every day under Section 66A of the IT Act, which is no longer law after Supreme Court struck it down. But this may be deliberate, this may be even not deliberate also. The policeman should know that Supreme Court has struck it down. It no longer is valid. Recently, Supreme Court expressed its dismay over continuing use of Section 66A, which the apex court said is null and void. It is not constitutional. So ultimately, what does it mean? It means the practice of democracy. The people in power should respect the constitutionalism. The various agencies in democracy, like independent judiciary, free media, active civil society, should guard against undemocratic practices that creep into the functioning of the system. So, therefore, in fact, these various Supreme Court judgments like Ram Leela Maidan case, Ramesh Thapar versus State of Madras, Himmat Lal Shah versus Commissioner of Ahmedabad, Dr. Ram Manohar Lohia versus State of Bihar. In all these judgments, Supreme Court clearly defined that any restriction on the right to protest should be reasonable, should stand the test of reasonableness. So there is an article by my article on right to protest and power to restrict in my website called knageshwar.com. If you can read that article. I have quoted number of Supreme Court judgments in that article explaining the relationship between citizens' right to protest and the power of the state agencies, whether it's a government, a court, or a police, state organs, to restrict this right. So that is precisely the functioning of democracy. I'll give you another example. There is a law of sedition. Quite often this law is misused in India. The recent example was the sedition case was filed against Raghuram Krishnaraj. It went even up to Supreme Court. The YSR Congress Party MP. Recently, KTR threatened the opposition, if you continue to behave like this, we don't hesitate even to hoist sedition cases. In both these examples, reveal how the law of sedition is misused. What is law of sedition? It is a British law which says if somebody speaks something against the government, this law is invoked. Normally, it should not be against the government, against the state. So the Supreme Court said, when we say against the government, it doesn't mean against the people in present government. If somebody criticizes Prime Minister Narendra Modi or Chief Minister Jagan Mohan Reddy or Chief Minister K. Chandrasekhar Rao, that doesn't mean a seditious act. So in 1962, Supreme Court in the Kedarnath Singh case gave a very interesting judgment. It said, unless there is an imminent threat of violence, somebody cannot be charged with the sedition case just because he spoke something. So there should be an imminent link to spread of violence. There should be an imminent threat of violence. But this was a judgment in 1962 limiting the use of sedition law, which is a colonial legacy. We got it from the British era. So, but still today, sedition cases are filed. Very recently, Supreme Court Chief Justice has expressed serious concern. If we have, when he said, when we are given a saw to cut a tree, you're actually cutting down the forest, he said. So when we have given you a saw to cut a tree, you're actually cutting the entire forest. This is what the Supreme Court Chief Justice, Justice N.V. Ramana said. So please read about this sedition law. There is more. I wrote a detailed article about 1,500 words in News Minute on sedition and free speech do not go together. This is the headline of the article. You just type Professor K Nageshwar on sedition and free speech do not go together. So you get a detailed article on this. It is available on the News Minute website. It is available on my website also, knageshwar.com. So, well, you will understand more. I do agree. There is a difference between what the Constitution says and how it is practiced. So there is a difference between the theory and practice. So you can't expect democracy or you can't expect constitution function with a laboratory purity. It is not just possible because constitution does not operate in a vacuum. It operates in a given social and political context. So therefore, you can't expect a laboratory purity in the implementation of the constitution. There are a lot of ifs and buts, there are a lot of questions. So ultimately, the democracy should have a self-corrective mechanism. If somebody is going off the board, people have to defeat that party. The court should intervene to curb the misuse of the constitutionally given power. The civil society should exert pressure. The opposition should exert pressure. So there is interplay of institutions in democracy so that it will correct itself. There's an election commission of India which has to intervene. So these are all agencies created by the constitution to ensure checks and balances. So ultimately, how the constitution is implemented is something which has to be seriously observed, debated, questioned every day. So that is how you make the constitution vital. Constitution, a really living constitution. It's not just a number of pages. It's not just a text what matters. It is the spirit of the constitution what matters. So that's the reason Ambedkar said, spirit of the constitution is the spirit of the age. So it has to be interpreted, reinterpreted, without losing its essence. And it has to be implemented, and there should be a struggle every day to implement it properly.